Okay, welcome and thank you for joining the Trust and Safety webinar about legal aspects of data sharing platforms. My name is Hannah Engel from the Data Intelligence Offensive and the TRUSTS project, and I will lead you through this webinar today. Shortly, Alessandro Bruni from the KU Leuven will start with an interactive pulse session about opportunities and challenges of data sharing. So please be prepared to answer a few questions and to share your opinion with us. And therefore, we will publish a link in the chat. So just click on it in a few minutes. After this, Lidia Dutkiewicz, also from the KU Leuven, will speak about frequently asked questions regarding to legal constraints of data sharing. And if there are still non-answered questions left, we will have a Q&A session where you can ask your questions. Therefore, please, if a question pops up, just write it in the question field, which you should find in your toolbar. So now I would say, let's start, and the floor is yours, Alessandro.
Thank you very much, and good morning, everyone. My name is Alessandro Bruni, and I'm an associated legal researcher from the Center of IT and IP Law. And today I will try to guide you through an interactive poll in order to understand whether our attendees understand when it comes to personal data, non-personal data, and which are the main issues related to the exchange of data in the online context. In order to have an interactive session, we will use a program that, of course, will process all data in an anonymized manner. And I invite you all to type in you can see on top of the window, there is a URL. So I would suggest you to copy paste. You can use your mobile, you can use your laptop. I would suggest to use Explorer if you can, because we have noticed some problem with Chrome, but let's try. And please let us know if we can do something in order to fix some last minute issues. So as you can see, this is a kind of an icebreaker, so please fill in so we understand a bit more where are you coming from and which is your area of expertise in the next slide. I will give for the most simple question about 45 seconds, while for the most challenging one, I will give more or less 1 minute. The whole process should take approximately 20 minutes. So I see that mostly we're coming from all Europe. Let's give other, let's say, 10 seconds. So in order to familiarize and to see if everything works. So here again, let's see if we can understand a bit more who we are and which are the attendees of this. Because according to the response we will get from these slides, we will understand also a bit more which is the level of information and knowledge about the topic. So I see that academia is well presented. Okay, it seems that we have a bit of everything, but mostly from academia. Other 10 seconds, let's say. Okay, let's start with something more challenging. Why are you attending this workshop? You can be a consumer and I would like to understand more about my rights and my understanding about how I value my data. As a legal counsel, I would like to know if I'm missing something, so if there is something to keep an eye on. As an entrepreneur, I would like to understand more about data value. Thanks God, no one is clicking on D so far, so I'm happy about this. So let's see, it seems that mostly we are legal counsel. I see the consumer group is growing, which is always something good. Here something more challenging, and here especially the legal counsel should kick in. So how do you define personal data? I think this is most important in the context of electronic communication and providers of services, because we have noticed that also with the reform of the e-privacy and the necessity to counterbalance the GDPR in a sense in order to have a complete framework, the differentiation between personal and non-personal data become every time more vague. We have seen there are some techniques that have been developed by different companies, but it's still challenging to understand, especially if we consider in a global scenario, if makes sense online to make a strong differentiation also in terms of protocols between personal and non-personal data. So it's interesting to see which are your response. So to quote something in order to give also the other, every piece of information that can identify a person, any info relating to an individual, information or any opinion about an identified individual or an individual who is reasonably identifiable. I guess these are coming from the legals. All personal valuable data which is owned by a legal and natural person. This is something we can discuss for sure. Personal data is information about an identified or identifiable person. And I think that here there is some knowledge about GDPR because I see some consistency. To be protected in case of private use or can be shared in case of business activities. I agree. Here, the other part, how do you define non-personal data? And it's particularly interesting to see because we have seen different legislative initiatives touching about non-personal data, but we are missing in a way a kind of clear cut about what is personal, what is not personal. Sometimes depends from the context where they are elaborated. We have seen a DPB on automatic vehicle, but it's still not clear cut, especially if we consider how other countries outside Europe can have the same definition. Data without a reference to a natural person. Interesting. Information that is not related to a person. Would be interesting to elaborate also on that, I guess. Any piece or set of data which does not contain personally identifiable information. Then data which is not directly or indirectly linked to a natural person. Let's see if we have something else, otherwise we skip to the next one. Person cannot be identified with it. Information relevant for some activities. Very interesting. I will go in 5. So in a day, how many times you give your consent online to private entities? So that can be not necessarily social networks, but also online journals, marketplace for processing your data. Of course, and this I want to say for those that are still waiting to answer, if you have some browsers that have collected your data and auto-filling your information every time you are using the service, you should not consider it, but you should consider as a new entry in order to answer properly to this question. So we see that there is also a significant percentage also sharing data for more than 50 times in a day. I see that the chart is stable, so I guess that everyone has answered, and we'll skip to the next one. Do you have an idea on how your data are used online? So since the presence of the legal is quite significant, I would imagine. Yeah. What is interesting so far is that no one has answered, I do not care about it, which is, of course, you are attending this workshop, so I would expect that, but it's still interesting to see, because sometimes you notice a kind of incoherence, especially in consumers when they share their data, given by their lack of knowledge about how data are shared and how they are exchanged between third parties. Again, here also seems stable, the situation. So do you think it is possible to value personal data? And I'm using here the term value in broader sense, and we will navigate a bit more and give a bit more nuance about what we consider as value of personal data. So here we see. And I guess the next question about depends will that will substantiate a bit more that depends, and we will see in more narrow way what we intend for value of data. So here again, in order to answer then the previous question, when we are talking about the benefits, and the first thing that appear self-evident to you, the reason that moves you to exchange your data online, you consider as an economic, you consider economic and psychological, or just psychological? I use the social networks because I like the personal satisfaction it gives me in knowing about my ex-girlfriend or my ex-boyfriend life. So, or is just I'm using in the business context mainly, so it is important for me to exchange this type of data in order to have a certain service that can be the possibility to read the newspaper, even though that can be also located as C. So it's very interesting to see that most of you decided to go for economic and psychological. So there are both elements. And of course, the difficult here is that how you assess and which are the instruments you develop in order to measure the psychological satisfaction, and how you balance the satisfaction with an exchange with your personal data. Here we go a bit more in detail because, as I said, especially the psychological element is something that is difficult to grasp, but also the economic one. So these are along the years, the different type of measurements, the methodology in order to value data that have been developed. Of course, there are pros and cons for each one of these, but it will be interesting to see which are, in your opinion, the most valuable one. And take into account that the first four are considering mostly from an economic and business side, where the last two have been used mainly to measure individuals' assessment on their personal data. Here you will be able to list and to rank according to your preference, which are the best one. So here we should see a kind of ranking. will give you more time because I know that it takes time. So it's interesting to see that number 1 and now number 4, so the individual, the methodology to assess individuals' assessment about the value of their data are quite high, while there are some others criteria that are quite low and are mainly for businesses, especially the cost for data breach. I think we can go on. So again, do you consider value of data beyond the economic one, psychological satisfaction? And can you argument this in the sense that knowing all the drawbacks of exchanging your data according to your previous answer, why is important for you, and which, especially if you act as a consumer, the economic value you gain from exchanging your data? Of course, there can be also other reasons. I'm doing a survey in order to improve the quality of a service, and I want to improve. I want to be part of a community and exchange data in order to have a certain type of knowledge or a better service. So if you can elaborate what you consider, especially if you go for psychological satisfaction about this, if any. Considering your previous answer, we should see something here. Very good. Very interesting. Exactly, because sometimes I notice that we tend to forget that our data can contribute to improve services provided by the state, the region, or the municipality. So this is a very good answer. Thank you. Very interesting answers. Ability to train yourself in a specific field by using knowledge, data as a product. Data should be used for a global benefit. Okay, certain research, exactly, especially in academia, we have seen that training and using data in order to train machine is a valuable way to grab data and process data, also personal one. Since this was more complicated, let's see other 30 seconds. To improve services which consumers can then benefit from. Very interesting. I noticed, because this is not, of course, the first time we have prepared these questions, it's sometimes difficult to move forward the economic assessment. So it's important also to have this kind of exercise to push also attendees, but also interviewers in understanding how data can be used also for better good, as someone say, or for research. So in the end, to improve the quality of our life, maybe. So it's very interesting, and we should all keep in mind that there are also other assessments. You value more privacy on personal data. This is in academia called privacy paradox. And we usually differentiate, now I wanted to tell, when you talk about privacy, you talk about the value and the cost of those programs that allow you to be anonymous online, or that allow you to protect better your personal data. So how much you spend in order to defend from external attack, maybe your personal data, when personal data themselves represent your personal data. So this is the main difference, at least in academia. Of course, this is something that is interpreted in a different way. So you value more the good or the tool to protect your good, if you consider good personal data. Very interesting, not clear-cut answers. So almost 40% of you value more personal data, while 30% give them the same level of importance. In valuing data, which are the most important criteria you consider? So the context, the quality assessment of data, the performance and usability of data in relation to the purpose or algorithms result. So here again, you should be able to rank them. Because of course, what we have noticed is that when you carry out an assessment, there is a lot of literature about how the data impact assessment falls short and doesn't take into account certain elements that should be taken into account, extracted also by the context, but maybe relate to the ethical dimension of the processing activity. Of course, here we will see that there is a differentiation between users and business. So business will be more interested in the performance and usability, while the context is something that is more direct in terms of also understanding for the consumers to make their assessment. Okay. So when you act as a consumer, do you use different criteria to value data, or there are some elements that you do not take into account? The way you act on social networks, the way you behave in certain contexts using certain services that you will not use because you don't want or you cannot when you are acting as an employee or employer. Okay, yes, so we see that there is differentiations, and it's interesting also because nowadays when we are talking about consumers, we are talking about a group of individuals that are characterized for a different, for a huge information imbalance, and so providers of service usually have a bargaining power in terms of what they provide them, what they exchange, and this has created also another category that is end users that include within this group not only consumers but also small businesses that have this same level of imbalance between the big providers and the small players. Do you think the value a company assigns to individuals' data correspond to your? So here let's see how big is the information gap, if there is, in your opinion, of course. Okay, according to someone, no. Okay. So far, just straight. So we see here again, there is a kind of acknowledgement about this information gap, due also to the technological complexity that is linked to the exchange of data in an online context by users. Okay, let's see the last one, I think. Why that happen in your opinion? So there are reasons why that happen. is for the complexity of the context, is the complexity of understanding how your data are processed, or there are some different issues? Here maybe it's more difficult to elaborate with, so I don't know if we can even move on, since I've seen that the clock is ticking, and we can discuss this during the Q&A. Yeah.
Yes, I think that
Yeah. Okay.
we can discuss it in the Q&A.
Okay.
So,
thank you for your time and patience.
Thank you very much, Alessandro. It was very interesting. And I will give the word to Lidia and let her talk about legal constraints of data sharing.
Lidia, you're muted.
Lidia, yeah. Lidia?
Can you hear me now?
Yeah, now it works.
Yeah, okay. Let's try this way. All right, so what we thought we will do in the second part of this webinar is to answer some frequently asked questions that we both encountered in TRUSTS project and in SafeDIT project. And I will focus specifically on the legal constraints of data sharing and try to answer the question what keeps businesses from sharing data and what can be done about it. So next slide, please. Yes, and as an introductory remark, let me start with the European Commission's data strategy. So data strategy is the document that the Commission issued in February 2020. And then the Commission noticed that in spite of the economic potential, data sharing between companies has not taken off at sufficient scale. And this is due to several reasons, but one of them being lack of trust. And I will come back to the trust issue because in our project in trust is of course one of the elements that we are looking into. And the second element, the second reason why the data sharing is not yet has not yet taken sufficiently is the lack of legal clarity on who can do what with the data. Next slide, please. And another introductory remark comes from the study on data sharing between companies in Europe. That's the study that was commissioned by the European Commission. And in the study, again, the legal obstacles have been identified as the most common obstacles to data sharing. And among these legal obstacles, we have the uncertainty about the so-called data ownership and what can be lawfully done with the data, along with difficulties in meeting the legal requirements on data protection. So these are the issues I will tackle later on. Yes, so moving on, the frequently asked questions about, indeed, what can lawfully done with the data in B2B context. Next slide, please. So the first question that we have to answer ourselves, the first question that we are often asked is what rules applied? What is the set of rules that apply to data and to data sharing? And it's important to note, to mention first that indeed there is no definition of data sharing, or there is no definition, legal definition in the EU legislation. What is shared data? That is now subject to the change with the European Commission Data Governance Act proposal. However, as things are for now, we don't have a clear definition of data sharing. And the EU legal framework that currently applies to data and to data transaction is a patchwork of very different rules. And we have some horizontal rules that are composed for personal data of the General Data Protection Regulation, so the famous GDPR. And for non-personal data, we have, depending on the context, whether we are talking about business to consumer relationship or whether we are talking about business to business relationship, we have either the Digital Content Directive or the free flow of data regulation. But that is not all, because we also have a vast amount of EU legislation that is indirectly applicable to data, such as a database directive, we have copyright directive, a trade secret directive. So all these elements of different legal framework constitutes this patchwork of different rules. And lastly, we also have the sectoral rules, for example, in the financial sector, in the energy sector, in the automotive sector. So the question, how can data exchange be achieved within this patchwork framework, I think is a great question, but it's also a sort of a holy grail question. And this is the issue that the European Commission is now trying to solve with yet another piece of legislation, the Data Governance Act proposal. The next question is, of course, is the data I have personal or non-personal? Because as I just explained, the answer to this question will then, the legal framework applicable to data will depend on the answer to the question. And as at first sight, we might think that the difference between personal and non-personal is rather straightforward. In essence, personal data concerns, as you rightly answer in the poll, it concerns any information relating to an identified or identifiable natural person. So I think intuitively we feel what personal data can mean. However, I would say intuition is not always a good advisor, and especially in that context here, the meaning of identified and identifiable has been really subject to many economic debates, as well as judgments from the Court of Justice, including the famous one saying that even the dynamic IP address can be considered personal data. So in conclusion, the precise determination of what can be deemed personal data is not always easy. And to determine that, we really have to take into account the factual situation, which is dynamic, which is context sensitive. And interestingly, the exact data set that might be considered as not personal at the start of the processing activity, later on can fall under the definition of personal, given tools and other additional information available to data controller. So another issue that I will not go in depth into, but is the problematic issue of mixed data sets. So what to do, how to consider the data set that consists of both personal and non-personal data. Next slide, please. All right, so now moving on to anonymization. So the question we also get in TRUSTS project is the data anonymized? And here the major distinction has to be drawn between pseudonymization and anonymization. And then to be very brief, if pseudonymization is done in a retraceable way, meaning that it is possible to backtrack the identity of individual using some additional information, that data is pseudonymized. It's not anonymous, which means that the GDPR is still fully applicable. However, if pseudonymization is done in non-retraceable way, which means that individuals are no longer identifiable, since the link between their pseudonym and identity is either non-existent or has been permanently deleted, then in general, this creates the anonymous information. And again, in general, in such cases, the GDPR is not applicable to the processing of such data. However, I say in general because we can never be sure, I think, from the legal point of view, whether the data is truly anonymized. And let me just mention that on the anonymization aspect, because we can go back one slide back to anonymization, because I wanted to mention the issue of this non-retraceable way of anonymization. And just today in TRUSTS project, we have finalized the book chapter on privacy preserving techniques, especially multi-party computation and fully homomorphic encryption, when we analyzed whether these techniques truly create anonymous information. So that's kind of work we also do in both in trusts and in SafeDit projects, to analyze and to work together from technical and legal perspective to work on privacy and privacy preserving techniques. Okay, next slide, please. Right, so as Alessandro already mentioned, the issue of data ownership. And let me start by saying that indeed thinking of data as a commodity, so as something that can be tradable, that can be turned into an asset, like this way of thinking is rather new. However, the whole idea of data marketplaces is based on this concept that we call commodification. So it means that in theory, data could be turned into an asset, could be sold, and could be exchanged. However, there is no ownership right as such on data in the member states in the EU, and most legal scholars also consider that there shouldn't be the ownership right due to the very specific nature of data. So the data is a specific item. It's not really an item. It's the specificity of data means that we have a fundamental right to data protection. And coming from this background and taking this as a starting point, we cannot really say that data can be just sold like any other goods. So we clearly see here the misalignment between the legal framework on one side and the economic reality. And how to tackle with that issue with lack of ownership, but on the other hand, we want to be able to trade data. This dilemma is something that is really lively discussed currently in the EU. Next slide, please. Right, so as I mentioned at the beginning, one of the legal obstacles to data sharing is the issue of trust. So the question, of course, rises, how can I trust that data I share is not misused? And many companies currently fear that indeed sharing their data would imply somehow a loss of the competitive advantage. And here is where the data marketplaces come into play, because the role of data marketplace is to be this trusted entity, to be this trusted intermediary that brings together suppliers and data users together to exchange data in a secure online environment. Now, the question rises, how can one ensure that the data marketplace really fulfills its role of the trustworthy intermediary? And there are different visions and ways to build trust. I would say that they range from architecture to design to the setup of the platform itself, a data marketplace, through security, high-level security, to, as I mentioned, privacy-preserving techniques and so forth. However, the European Commission has now, next slide, please, another idea of how to build trust, how to enhance trust. And that idea is now discussed in just issued in November last year, the Data Governance Act proposal. So I'll just mention briefly how the issue of trust is tackled in the DGA. So with the DGA proposal, the European Commission, in order to increase trust, wants to create an EU-wide regulatory framework which would set out harmonized requirements for data sharing services. So as I mentioned, currently we have this patchwork of legal norms. What the European Commission wants to do is to increase trust and to create the trustworthy environment of data sharing services via the harmonized requirements. So how will data intermediaries ensure trust in data sharing? Well, the answer is neutrality. So in the European Commission view, data intermediaries, such as data marketplaces, will pool and will organize data neutrally. What that means in practice? Well, there are two components of this neutrality requirement. So the first one is that data sharing intermediaries, data marketplaces, will not be able to exchange the data for its own interest. for example, by selling it to another company or using it to develop its own products based on the data they receive. And the second component is that data sharing activities will be strictly separated from other data services. And that goes as far as to require the separate legal entity for data sharing activities. And the last element is that the data and the metadata acquired can only be used to improve the data sharing service and will not be able to be used for any other purpose. Next slide, please. Now, moving on to the obligations that the third-party intermediaries, such as data marketplace, have. So I would just briefly two aspects here, because in fact, on that topic specifically, we have in TRUSTS our deliverable on legal requirements for data marketplaces when we analyze in depth on all the legal frameworks applicable to data marketplaces. However, the platform to business regulation is the one important in that context. And as you see on the slide here on the right side, well, first it is necessary to understand to whom the platform intends to offer its services, because then it might determine whether it will fall or not within the platform to business regulation. Now, if it does, the P2B regulation promotes in general these two main principles. So the first principle is transparency principle. That means that the platform has to have a clear and unambiguous terms and conditions about the treatment, the criteria used to rank their products, about the requirements to suspend or terminate their services, and so forth. And the second principle is the fairness principle, which requires platforms to have an effective out-of-court redress mechanisms, such as internal complaint handling system and mediation. Next slide, please. Now, the Data Governance Act proposal that I already mentioned also introduces some additional obligations to third-party intermediaries. So under the DGA, data intermediaries will be required to notify the competent public authority of their intention to provide such services. And these public authorities will monitor the compliance with the requirements, and then the European Commission will also keep a register of data intermediaries. What's more, Article 10 and 11 of the DGA proposal provides a long list of different notification duties and conditions that data sharing services will need to comply with in order to provide data sharing services across the EU. So what are these notification duties and obligations? There are many, as I mentioned, and I just mentioned here some of them. This is not the exhaustive list of the obligations. However, let me just mention a few here. So the first one is the obligation to appoint a legal representative for providers if they are not established in the EU. Then the neutrality requirement. So the neutrality requirement that I already mentioned includes the prohibition of cross-usage of data, and also an obligation to have data sharing services in a separate legal entity. Then data sharing service provider will have to have fair, transparent, non-discriminatory procedures for access to their services, including as regards prices. Then there's the requirement to ensure a reasonable continuity of provision of the services. Furthermore, third-party intermediary will have to have in place adequate technical, legal, organizational measures in order to prevent transfer or access to non-personal data, and also measures on high level of security of the storage and transmission of non-personal data. So I will not go in detail into these requirements because this is something that could be subject to a separate webinar or series of webinar really on the Data Governance Act proposal. And I will now move to the last question that we got, which is how will data marketplaces be organized in the future? And that's a very interesting question, and of course we don't have an answer to that one. But from what we can see already from a Data Governance Act proposal is, for example, the emergence of different categories of data sharing providers. We have the novel concept of data cooperatives. We have a new idea of establishing data altruism organizations. So we have all these different new concepts that are somehow related to data sharing. The European Commission is also wants to establish the European data spaces in various sectors. Then I would say the role of data interoperability and the standardization is likely to be even more important in the upcoming months and years. And finally, we have a Data Act that we don't have much information about yet, but the Data Act on rights on access and use of data is something to be expected later this year. So with that, I think I will stop in order to be able to answer some questions, and I thank you very much.
Thank you very much, Lydia. So if there are any questions for the Q&A session, please put them in the question chat field. And while we wait, maybe Lydia, can you tell us if there are any key upcoming legislations?
Yes, I think that, as I mentioned, the Data Governance Act proposal. So now we have a proposal that was issued in November, and I think this is the key piece of legislation that is very much important for data sharing services. And I think it will probably take a few months, if not years, to have a final draft. So I would say I would propose to look how the act will develop. And this is something that we will do in TRUST as well, because we want to see how these different requirements I mentioned briefly, how they will apply to data marketplaces such as in TRUST. So I would say this is one of the key legislation act that is there. The Data Act, as I mentioned, also is a valid one here in this context. But I would also maybe look at the Digital Services Act, because this is also the very new legislative proposal that regulates the platforms and platforms environment. And I think it's also it would be interesting to research upon the aspect whether and to what extent data marketplaces can be considered as a platform, and how this, all these different and new legislative proposals interact with one another. I think that would be, yeah.
If I can add, there is also the e-privacy regulation that is going to be crucial in this context in order to see to which extent the legislator will ensure a same level of security to not only natural persons as it was till now, but also legal persons. So the reform has taken more than expected. I think it started already in 2016, and we haven't seen the light yet. The council has approved, I think 1 month ago, his text, and now they will start a negotiation that might take quite a long time. It is important also because in the scope of application, we might have also machine-to-machine communication, which have been left out of the discussion so far also in GDPR, and represent a kind of blurry and not well-defined group of communication that in reality with the IoT is going to represent the majority of the communication we will have to deal with. So should we ensure the same level, the principle of confidentiality of communication also to communication machine-generated data and communication occurring between machines, how we can investigate. And to substantiate also to what was saying Lydia, there are 3 elements that are emerging as important and should be taken into account. So on one side, the security measures and the transparency should take into account fundamental rights and personal rights of individuals, legal interest of legal entities that can be related to patents, to client list, to how many products they buy or sell, and also the possibility for, according to the rules and the safeguards that are provided by Article 8 of the Convention, European Convention, the possibility for the member state to investigate, so to seek information in order to see that the procedure that are in place comply with the given framework. And I think this is going to be very interesting to analyze and to see.
Thank you both. We have a few more questions coming in. First would be, what do you think of the EDPB comments on the DGA?
I can maybe say, well, the DGA and the EDPB comments, that's a very good question, and I think that, well, I can say that we have internally in CTIP Leuven now something that I would call a task force on the Data Governance Act, and we are currently drafting a white paper on the Data Governance Act, where we are, looking into both the EDPB comments, and we are also critically analyzing the DGA that has a lot of, I think, room to interpretation, to maneuver, and to improvement. So I would maybe leave it as such to encourage everyone to wait a bit longer for our white paper on the Data Governance Act that we will, I think, publish very soon in mid-April, hopefully. So we will be very happy to share it with everyone. And now, Alessandro, if you have any specific input?
Well, I was reading the question before answering to the previous one, and of course, one of the points that has been stressed is the necessity to establish an harmonization between the initiatives that have been developed so far. So always keeping an eye on GDPR, and in my opinion also on e-privacy is certainly something that we should take into account, and at the same time the issue that have been raised in terms of governance, and with governance I mean who is responsible to investigate. So again, what I was saying also in relation to the privacy, these are two crucial aspects that of course we will have to investigate, and also the nuance of the definition and the coherence of the definition with existing legislative framework is something that we should analyze. But as Lidia fairly say, this of course is a kind of guidelines that the agencies have given us in order to have a look and to monitor the development of the legislative procedure. So we cannot, they have raised some points that are agreeable and cannot be differently, but at the same time we have to say, in order to see if the recommendation of the EDPB have been fulfilled in the final stage of the legislative development. So we have to wait, but of course coordination and importance of GDPR and the e-privacy is crucial, and governance too, because we cannot have situation where agency in one country will regulate in a certain way with certain patterns and with certain also economic possibility in terms of workforce and time, while we will have other national agencies that are more laid back, because this might raise the situation of a forum shopping where we have weird companies or situation that may raise some problem in terms of ensuring a same level of protection across the EU.
Thank you very much. As there are a lot more questions, as I can see, I would say, because we're running out of time a bit, we will collect all of your questions. So if you still have some questions, just put them in the tool and we will collect them and answer them in a short FAQ on the website, if that's also fine for you two, Lidia and Alessandro.
Yeah,
and,
sure, definitely.
And then we can answer all of your questions, because there are a lot coming in. So thank you very much for participating. Thank you, Lidia. Thank you, Alessandro, for sharing your knowledge with us. And we will reach out to you again with the FAQ and with also a follow-up report on our website. It will also be possible to watch the webinar again if you want. And if you want to stay up to date, you can follow us on LinkedIn or Twitter. You can follow the TRUSTS project as well as the safety project, and also KU Leuven is on Twitter and I think LinkedIn as well. So thank you again for joining us today and have a nice day.
Bye.
Thank you. Bye-bye.